Welcome to this presentation on the General Data Protection Regulations, or GDPR for short, that came into force on the 25th of May 2018. The presentation takes approximately 20 minutes, which I hope you will find informative. There are two main sections to this presentation. We will start with an overview of GDPR and the main changes in data protection legislation compared to the previous Data Protection Act of 1998. We will then look in more detail at the key changes and how they affect parishes. So what is GDPR? GDPR has been brought in to strengthen data protection for all citizens in the EU. Brexit doesn't come to the rescue, I'm afraid. GDPR is still applicable in the UK. The fines for breaching the legislation have been increased substantially to up to 4% of turnover. However, the road to compliance can be achieved through some simple first steps. Firstly, develop an awareness of data protection and look at how your parish handles its personal data. 2. Audit and review the systems that are currently in place. 3. Assess the parish's privacy notice and procedures, or prepare one if the parish does not yet have one. The Parish Resources website has templates you can use and adapt. And finally, make sure there are procedures in place to handle subject access requests. Let's have a brief look at the data protection principles. These are the foundation stones of GDPR. The first data protection principle emphasises that personal data must be used lawfully, fairly, and with transparency. Clarity is the key here. The data must be used for specific, explicit, and legitimate purposes. It's no longer acceptable to collate vast amounts of information, which includes personal data, just in case it's needed one day. And the data must be used in a way that's adequate, relevant, and not excessive. The data must be kept up to date. The data should not be kept for longer than necessary. Here we're talking about retention periods, and the retention tables can be found on the National Church's website under Records Management Guides. Ensuring security and protection for the personal data that we keep and being able to demonstrate compliance with all of the principles is of particular significance. It's not just about compliance, but it's also about having evidence of being compliant and keeping records to prove it. GDPR is still developing, and in fact the legislation is still open to amendment and further developments alike. The ICO's website, the Information Commissioner's Office, has a page that is updated monthly to highlight new developments. Key definitions. Personal data only refers to living individuals, not anyone who's died, and it covers all identifiable information such as a name or even an IP address. Processing is anything at all that is done with personal data, which includes collecting it, storing it, and amending it. A data subject is the person about whom the data is being processed. The data controller is the person, or more usually the organisation, who determines the hows and whats of data processing. This is usually the vicar or the PCC, and they can be held to account for anything to do with data processing. So what does GDPR mean for us? GDPR is an enhancement of the provisions in the previous Data Protection Act. An analogy I could use here is if we have a small car that we've driven for a long time, and then we buy a car with a turbo engine, then we'll notice the difference. Similarly, GDPR takes the Data Protection Act that step further, building on what has already been in place. Let's now have a look at the overview of the key changes. 1. Accountability. It's not just a case of being compliant. We need to demonstrate that we are compliant. We need to know what personal data we have. We may have lots of information, but perhaps we're not sure where it is or what it is. But with GDPR, we need to know that, and we need to be able to account for it. This includes stuff on our desks, in drawers, anything held electronically on the cloud, or mobile phone, or at home. 2 and 3. Privacy notices, which may also be seen as data protection notices. You may have already seen them on a website on your computer as a pop-up that you scroll down to tick consent to, or else you can't move on. They now have to be more detailed and need to state what data you are holding, the legal basis you are holding and processing that data, the length of time you are holding the data, and the right to complain. They are more beefed up and need to be clear on what we are doing with people's data. 4. For data breaches, the main issue here is that the time frame for reporting breaches has changed to 72 hours, and mechanisms need to be in place so that you know how to handle it. So if a breach happened on a Friday, it would still need to be reported by Monday, which may mean people working over the weekend. It does not respect bank holidays or any other type of holiday. 5. The legislation is aimed at protecting individuals. Society is now more litigious and people understand their rights more. It's likely there will be an increased demand for subject access requests, or SARs for short. As an overview, generally we need to be more conscious of why we are processing personal data. Am I processing in line with privacy notices? If we had a subject access request, is there anything we would be embarrassed about in holding that data? Let's look at the changes in more detail. The first one is data audit and recording, which is a search and analysis of the data, knowing what we've got and being able to give an account for it. Data audit begins with questions of the what, how, why, when, who, where. Not knowing what data you have is dangerous. We need to know the data that we have, where it comes from, who it belongs to, and why we have it. The audit questionnaire that you can find on the Parish Resources website will help you to answer all these questions. Someone in the parish needs to complete this audit covering all the personal data the parish holds. There's an example given, as you can see on this slide, on gift aid. Using this audit questionnaire, you need to ask, what personal data do we hold? Where is it held? Electronic, including mobiles, paper-based locations, and so on. Where has the data come from? What's the data used for? Who can access the data and why? Is the data shared with third parties? We need to make sure that the right people have access. Actions that the PCC may need to take include identifying a place to keep the data. This may be moving it from a number of locations to a centralised place. Taking steps to improve data security. This may include password protection or encryption if the data is particularly sensitive. Maybe you're holding data that needs to be deleted. This is now a good opportunity to get on with it. Although be careful, don't delete information that's needed for the work of the church. You'll need to think about it. A data breach is a breach of the security of the data leading to the accidental or illegal destruction, loss, alteration, unauthorised disclosure of or access to personal data. It can happen in various ways, and this is where the ICO will fine if things go wrong. I've tried to list the most common forms of data breaches, but please don't see this as an exhaustive list. 1. The transmission of emails. It's a big area. We can easily attach the wrong document and send it to the wrong people. Also, with email chains, an email can start on one subject and get changed to another halfway through, and this may include information you don't want to send to other people. A paper document could be left for the vicar to look at, for example. It may be sensitive though, and other people may wander in and see it. Sensitive data should not be left out in the first place. Laptops, memory sticks, or even mobiles can be misplaced. Do they have a password? Are they encrypted? If we have sensitive details such as salaries, do they just go in the bin? Are they shredded? Or is your confidential waste just sitting, waiting for someone to go through it? Also, have you left the original on the photocopier for someone to find and read before they realise who it belongs to? If we have fixed computer screens, who else can see the information on it? If you work in a coffee shop on a laptop, who else can look over your shoulder and read it? And do you know the security of your IT system? It's very important to make sure your IT is secure. As I've already mentioned, these are just a few instances. There may be other ways in which data can be breached. The key thing is to avoid a data breach rather than be exposed to reputational damage and possible fines. Outlook is good when it auto-completes the email address, but it may be incorrect, so always double check. Using BCC not only stops people seeing others' email addresses, it means people cannot just hit reply all and things go round in circles. Also consider attachments in emails in case they're sent to the wrong person. If the attachment has sensitive data, is it password protected, or could it be held on the cloud, such as OneDrive or Dropbox, where only specific individuals can view it? Always ensure cupboards, drawers, offices are locked when unattended. As mentioned previously, everything needs to be locked when not in use. And finally, assess your IT security. Can someone hack in? This is a changing culture, and there is still a risk of a data breach even though extra steps will have been put in. In the event of a data breach, the lead data protection person in the parish should be contacted. It's a judgment call whether it needs to be reported to the ICO, so it may take a few people to decide what to do. Breaches that need to be forwarded to the ICO are where there's a risk to the rights and freedoms of the individual. They need to really be done on a case-by-case basis. Also bear in mind that the person responsible for the breach may be feeling sensitive and upset, and so they will need looking after as well. Reporting a data breach. If something happened on a Friday, could you be ready to report on a Monday? Even if you don't have to report to the ICO, the breach still needs to be recorded and action taken. So if it's August, people are all on holiday, a plan needs to be put in place on what to do. The worst thing is that something happens and you don't have a procedure in place as to what to do. Rather than work by chance, work it out now. There are 8 individual rights which we can see on this slide. 1. The right to be informed about your data relates particularly to the privacy notice. 2. Accessing the data is about subject access requests and data being made available to individuals. That's why we need a data audit and review, so that we know where the data is held. 3. Mistakes such as incorrect addresses need to be updated. 4. If, for example, someone is aggrieved, they may ask for everything to be erased. However, be mindful that there are certain circumstances when we will have a lawful basis for keeping data, such as safeguarding situations or information about payments or tax. 5. Someone may just ask you not to process their data. 6. Making the data portable is probably not something you need to concern yourself with. This is more applicable to institutions like banking. 7. Objections to processing often happen in marketing. We've all had times when we've wondered, where did they get my email address? And we've asked to unsubscribe. 8. Automated decision making is again not really applicable to parishes. The 2 rights that we will look at further are subject access requests and the right to be informed. Subject access requests is the right to access data. People have a right to check if their data is processed and if it's accurate. SARs, as subject access requests are known, can come in anyway and from everywhere. They won't necessarily come in an email all neat and tidy with a subject line saying SAR. Would you recognise an SAR and know what to do with it? The time limit's much shorter now and has to be responded in 1 month or 30 calendar days. There is also no fee applicable any longer. Care needs to be taken, as you may not find much in one area, such as in your paperwork, but there may be lots elsewhere. For example, in recruitment, you may have destroyed a paper copy of the CV, but it may still exist on an email attachment. The key thing is to start the SAR straight away. Identify those who have IT skills in the parish and those who have a lot of historical knowledge of the parish. Whoever is enlisted to carry out the SARs, make sure you look in the right places. When doing an SAR, make sure any information about other individuals is redacted so that their data isn't shared. You need to black it out or highlight it in black if it's an electronic document. You also need to make sure the individual is who they say they are, and so if you don't know the person, do an identity check, or else this could become a major data breach. You may want to ask the individual requesting an SAR if they can give a particular time frame or a specific event. The individual doesn't have to do that, but if they're willing, then this will help you narrow down the search. However, you need to act within the time frame. Remember, if the key person is on holiday, others will have to know what to do. It's possible that SARs will become more frequent than before. And remember, the delete folder on your computer is still storage and needs to be included in an SAR. Proper deletion is to delete from the delete folder. Also, if you need further information from the individual requesting the SAR, you can go back and ask. Privacy notices cover the right for individuals to be informed, and they're more detailed than previously. All organisations, including charities, need to be upfront, and the PCC should make privacy notice available to all the people whose data they process. Due to the amount of detail held in privacy notices, they can be quite lengthy. Gdpr has a long list of requirements, and these are explained on the Parish Resources website, which gives parishes a template to work with. No response is required to privacy notices, but they must be made available. There are 2 privacy notice templates on the Parish Resources website. These have been carefully drafted for the parishes, and they shouldn't need to be amended other than with the parish name and so on. GDPR isn't a comfortable fit for our environment, so there are 2 templates. The one for role holders is aimed at those fulfilling roles, including volunteers, deanery synod members, PCC members, and so on. Their data will need to be processed legitimately so that they can carry out their role, and so that their data can be passed without consent to the diocesan and bishop's office. This is reflected in the template notice for roll holders. Non-roll holders include ordinary churchgoers and those on the electoral roll, suppliers, and so forth. Privacy notices do not need to be signed or have a response, but they need to be readily available, and so should be included on the website if you have one, or put at the back of the church for people to pick up. Or you could give links in newsletters or notices. Be aware that privacy notices may need to be explained to individuals such as those with learning difficulties. Consent. It seems strange to have to gain consent for newsletters and activities which are part of the church life. This is generally where the newsletter is addressed to individuals. However, if they're made available for anyone to pick up, then consent is not needed for that. You could think about including consent forms in welcome packs, or making them widely accessible, such as at the back of the church. And indeed, the form used to update the electoral roll can be used to gain consent. Consent now needs an opt-in. We can no longer rely on people receiving a newsletter unless they tell us otherwise. With consent, the individual is required to actively opt in, such as by ticking a box. It also needs to be easily withdrawn, and parental guardian consent is needed for children under 13. Even though GDPR states 16, the UK law is that it's needed for children under 13. Consent can be received by email or in paper format. Do make sure that any youth workers or other volunteers are clear about consent and about privacy notices as well. Again, a sample consent form is available on the Parish Resources website. The key points on contracts are listed on this slide. The third parties referred to on the second point include organisations that the parish may use, such as IT companies. Where written contracts are given, do make sure that they include the GDPR obligations and clear liabilities. Any third party that processes the parish's data must do so only under parish instruction, ensure confidentiality, and keep the parish's personal data secure. So, where do we go next? You may find it useful to look at the questions and answers document that's now available on our website, www.carlislediocese.org.uk. It's important that everyone in the PCC is aware of the data protection regulations, and maybe they would like to have a look at this presentation and look at the GDPR toolkit that's available on the Parish Resources website. Give some time to the data sorting and review. It may take longer than you think. Make sure all the key policies and procedures are in place, including privacy notices, consent forms, what to do in the event of a subject access request, making sure the data is held securely. I hope this presentation has helped you to understand the new regulations better and that the parish is ready to demonstrate compliance. And finally, thank you for taking the time to listen.